Thank you.
Matter 549 of 2019, MC versus GC.
Yes, thank you. The matter of MC versus GC, matter 549 of 2019.
As the court pleases, my lord, I appear on behalf of the applicant in this application for joinder and amendment and various interlocutory applications.
Thank you, Ms. Veldsman.
May it please you, my lord, I appear for the first and second respondents. I'll just refer to them as respondents during argument, my lord. That will be much easier.
Yes, thank you, Mr. Nepkin. Yes, thank you.
Also, before I mute myself, there's just an amendment to the notice to strike, which it might just be convenient to do at this stage. My lord, there was a notice of intention to amend. The applicants indicated they have no objection. My lord, the application I have in my papers at page 172, and your lordship would see on the second line, application to strike, there's an erroneous reference to the founding affidavit instead of the replying affidavit.
Yes.
My lord, might we just ask that your lordship would amend the reference to the founding affidavit to that of the replying affidavit in the second line.
Yes, thank you. Yes, that will be amended accordingly to refer to the replying affidavit.
Thank you, I'm indebted to your lordship.
As the court pleases.
Yes, thank you, Ms. Veldsman. You may proceed.
My lord, your lordship would have noticed that I've sent through yesterday and also this morning just a further authorities that was not included in my heads of argument. It's a further list of authorities, but it's also based on the same principles already being addressed in the heads of argument and also in my supplementary heads of argument. It's just to bring the message home that I've also going to rely on the further list of authorities.
Yes, we did receive a further list of authorities. There were several which referred to the publication of the matters in SAFLI. Is that the one that you refer to?
My apologies. I don't know where we left off.
We had a slight break in the connection for some reason, and I'm not sure where we were. I think what we were dealing with was the reference to your further heads of argument, and I had asked whether the document you sent through was the one referring to the several cases reported on the website SAFLI, whether that was the correct document that you were referring to.
Judge, let me put everything in perspective. There was heads of arguments served and filed with a 15-hour practice note and a list of authorities.
Yes.
Then, after having received the respondents' heads of argument, supplementary heads of argument with the amended list of authorities, incorporating the first authorities, was also sent through. And then on yesterday afternoon, my attorney sent through a list of authorities referring to three matters, U versus U, VW against VW, and then also B against B. And then this morning, she sent a further list through, which incorporates that up to paragraph 9 of the list of further authorities. The one matter that I want to refer your lordship to, which is, I don't know, it escaped myself when I was drafting the heads of argument, not to incorporate that in the heads of argument, is the matter of B against B, where it also refers to the matter of the Honourable Justice Alkmaar here in the Eastern Cape, RP against BP, where that was also discussed. And the other authorities mentioned therein is just to bring the point home and just to clarify what the test for joinder is and why a joinder in this matter is prudent to join the trust also in the divorce proceedings. Your lordship would notice, and I'm not going to repeat everything that's said in my heads of argument, your lordship would notice that initially the test for the joinder of the trust was not really addressed in the heads of argument, and the reason being that the applicant did not understood the respondent's case to say that we did not comply with section 10.3. The answering affidavit, as the applicant interpreted, and if I say the applicant, I'm including myself, was that there is no cause of action against the trust because it doesn't comply with the Trust Property Control Act, the allegations made in the notice of intention to amend. The issue of that it does not satisfy the requirements of section 10 was only raised in the respondent's heads of argument, and in that sense that was the need for the supplementary heads of argument, and also then just to refer your lordship's attention to the matter of B against B. Now, lordship would notice that the test, and it's been reported and confirmed by the Supreme Court of Appeal in the matter of the Judicial Services Commission against the Cape Bar Council, South African Law Reports 2013, number 1, page 170, and it's at paragraph 12, where the court said, and I can just read it to the court, that relevant paragraph. I don't know if your lordship had chance to read through the judgment, but in paragraph 12 of that judgment, it was said, it has now become settled law that the joinder of a party is only required as a matter of necessity, as opposed to a matter of convenience. If the party has a direct and substantial interest which may be affected prejudicially by the judgment of the court in the proceedings concerned, the mere fact that a party may have an interest in the outcome of the litigation does not warrant a non-joinder plea. The right of a party to validly raise the objection that other parties should have been joined to the proceedings has thus been held to be a limited one. And then he refers to various judgments in that discussion of the non-joinder issue in the matter of the Judicial Services Commission against the Cape Bar Council. Now, in order for me to satisfy that test, I want to address your lordship on the notice of, on the founding affidavit, and also then on the replying affidavit. And your lordship would notice in paragraph 16 and 17 of the founding affidavit, it actually starts in paragraph 13 on page 9, where the applicant states the reason for the joinder of the trust, being the second to fourth respondents, because they were the trustees of the trust. The first respondent is the beneficiary of the trust. The first respondent used the trust as a vehicle to finance his personal estate. Trust paid the personal expenses of the parties. The business of the trust was conducted as a partnership between the applicant and the first respondent and the trust. And then I intend to request dissolution of the partnership at date of divorce, or alternatively at a date as agreed between the parties. And then she goes on in paragraph 16 and she explains the business of the trust and why she says it's a partnership. And your lordship will find that reference on page 10, going over to page 11. Now, if your lordship considers that the applicant intends to amend her pleadings in accordance with Annexure MAC 9, and I will address your lordship on that issue in due course, but I'm first dealing with the joinder of the trust. But if your lordship notice, in Annexure MAC 9, attached to the replying affidavit on page, I'm going to refer your lordship to the contents on page 135, paragraph 6.5 of the replying affidavit. Your lordship would notice that the contents of Annexure MAC 9 is discussed in the replying affidavit also. And there she states very specifically the reasons why she again needs to join the trust and how she's going to join the trust in paragraph 6.5.1, 5.2, 5.3. And then she says in paragraph 10.3, read with 12, that it's further contended in light of the allegations made in support of claim to that trust ought to be joined to the divorce action because the outcome of the divorce action will affect the trust. And then she says in paragraph 12.2, she's not merely an employee of the trust, the trust and the applicant are partners, as she alleged. And she says then,
we seem to have another. Mr. Extian? No, he's there. Mr. Nepgen? Seems to be.
on page 12.
Sorry,
on
Ms. Veldsman, we had a minor break in the feed, and it is on my side, and I think that what the difficulty is Ms. Marlene Clark, who's joined, I think she may join as a host, and that might interfere with my hosting of the hearing. So perhaps it seems to be working now. And I'm hoping that we're not going to have any further. If you'll just allow me a moment.
My Lord, we've requested our client to leave the meeting. So
I've just placed her in the meeting room, and I'm going to readmit her in a moment as the guest, and hopefully that will resolve the issue.
Thank you, my Lord.
Thank you. Perhaps if you could just indicate to your client that it was just to resolve a technical problem.
Thank you, my Lord. My attorney is on it. She's confirmed that she can again attend the meeting. I think that we left each other on page 153 in paragraph 12 of the replying affidavit.
Correct.
Now, the reasons for joining of the trust, that was discussed in the paragraph 11 of the replying affidavit. Now, in paragraph 12 of the relief sought, your Lordship would notice that the first part of the relief sought is an ordinary relief that you claim in the divorce action. And then in paragraph 12.2 of the replying affidavit, page 155, your Lordship would notice that in claim 2, under the relief sought, she's asking an order directing the second and third defendants to render to the first defendant an account of all partnership transactions for the period March 2001 until date of divorce. And then in paragraph proposed 12, that a liquidator or receiver be appointed to do the debatement of the account. And then if your Lordship goes back to page 154, your Lordship would notice that the determination and calculation of the accrual in the plaintiff's and the first defendant's estate be referred to the same liquidator appointed and tasked to dissolve the partnership between the parties as prayed in prayers 11 and 12. Those are the ones that I've read to you just now on page 155. And your Lordship would notice that if one then continues to page 155, it's exactly the same liquidator. And the reason why she requests that the same liquidator be appointed is the reason that the partnership, the share of the partnership of the first respondent will affect the accrual in his estate. And the accrual in his estate is part of the divorce action. And it's going to be one and the same type of trial if the trust is not joined and the partnership is dissolved at a later stage. And the reason for that is, if your Lordship consider the argument that was raised in the matter of Beer against Beer, and then the ultimate judgment of the Honorable Justice, if I'm not mistaken, it was Riley, where the court found that because of the issues raised in that accrual claim that is so interlinked with there also the issue of partnership was addressed, because those issues are so interlinked with the accrual claim and also with the maintenance claim, and your Lordship would remind yourself that in this matter there's a maintenance claim and an accrual claim, in our matter also, that it is convenient and it is necessary to join the trust. Now, your Lordship would notice that she says in her Annexure MAC 9 that on page 150, she says, first she starts with the joinder of the trustees, and then she says that I just want to get to the correct part. Your Lordship would just bear with me.
Me?
She says in her replying affidavit in page 142 and 143, in paragraph 12.8, it is evident from the proposed amendment that the partnership claim will affect my maintenance and accrual claims in the divorce action, and that the trust will be affected by the divorce proceedings. Hence, it is necessary to join the trust to the divorce proceedings. Now, if your Lordship read that with the contents of paragraph 16 and 17 on pages 11 and 12 of the founding affidavit, those allegations are substantiated, the ones in the reply are substantiated in paragraph 16 and 17. And she says that paragraph 17 on page 12, in the premises, it is submitted that the trust ought to be joined as a party to divorce proceedings because its business, assets, and liabilities are going to be affected by the outcome of the divorce in light of the relief sought as intended in the counterclaim. Now, the reason why she's saying that, if your Lordship makes an order, and your Lordship is going to make an order that the accrual is going to be, must be divided between the parties, although your Lordship cannot say at the time when if your Lordship is the judge in the divorce, for example, your Lordship will not at that stage maybe be able to say what the accrual is, and your Lordship may defer it to a receiver or a liquidator. Then your Lordship is going to have difficulty in able to ascertain what the value of the estate would be and what the accrual would be for the parties. And the reason why it's going to be difficult is because your Lordship, if the trust is not joined, your Lordship is not going to be able to determine the value of the share of the first respondent's partnership in the trust, and also the value of the share of the applicant's claim in the partnership. And those claims falls part and parcel, part of the respective estates. And your Lordship will then have to either postpone the matter and then join the trust at that stage. Alternatively, in the divorce matter must be postponed, the accrual, the division of the accrual must be postponed, and the parties must then start a new matter with the partnership claim separately. And then after that has been dissolved, the partner's claim in the partnership will then be added to the accrual claim, and then the accrual can only be divided. And that is the reason, my apologies.
No, carry on.
And that is the reason why the court also found in Beer against Beer that it is prudent to join the trust in the divorce proceedings in accrual claim, because of if the trust at that stage in Beer against Beer was not going to be joined, it's going to happen that the accrual will not be able to be determined at date of divorce. Alternatively, by a receiver, will only be able to do that after the trust issue has been dissolved and the partnership of the trust has been dissolved. And in those circumstances, the court found that because of the maintenance claim, the accrual claim, and the partnership issue, which forms part of the estates of the parties, the trust should be joined in those circumstances. If the accrual claim of the applicant is sufficient to support in maintenance, then obviously the court's not going to make a maintenance claim in terms of section 7.2. But the court cannot decide whether she will have a valid maintenance claim or not during the divorce if the accrual has not been either settled or been determined by either the court or the receiver or liquidator. Because if it's 100,000 rand in the accrual that she's going to receive, she cannot support it in terms of a maintenance claim. But if it's 1 million rand, she will in all probability be able to support herself just as a figure of speech. But in order to get to that decision, your lordship first needs to decide in the divorce matter what the accrual is. In order to decide what the accrual is, the partnership share of each parties must first be decided and then be added to the estates.
Well,
and that's the reason why the joinder is necessary.
Could I ask you this? In the proposed amendment, which is set out in MAC 9, what relief, if any, is sought against the trust?
The division, the dissolution of the partnership. If one considers MAC 9,
is that formulated in the form of an order that you would seek?
She says that, well, the dissolution of the partnership she's asking that, she's not asking, I see now, she's not asking for dissolution of the partnership in the relief sought. She's asking that the accounts be rendered of the partnership transactions and then a liquidator be appointed. So what needs to be added is 11A, is to say a dissolution of the partnership, and then 11B, an order directing the second and third defendants to render the accounts.
Yes, I ask the question because it bears upon an argument which no doubt we will hear in due course about the fact that the joinder that you seek is not to join the trust in reconvention, but rather in convention. In other words, in the main divorce proceedings as a defendant, whereas there is no dispute between the plaintiff and the trust.
Well, my lord, what will happen is she is not asking for joinder of the trust in the main proceeding. She's asking for joinder of the trust in the counterclaim. And the reason being is for claim 2. And the reason why the trust must also then be joined in the main lists, in the plaintiff's action, is because the plaintiff is asking for division of the accrual. And in order to divide the accrual between the parties, the applicant says in the counterclaim, I have a claim against the trust. And the court cannot, in the main claim, decide the accrual
Yes.
if the counterclaim has not been decided upon the partnership.
The claim against, well, you refer to a claim against the trust. Let's use that terminology. It is for the dissolution of the partnership which is alleged to exist between your client and the trust.
Yes.
That's what's set out in MAC 9.
Yes.
Now, the consequence of that would not be that whatever, let's assume a partnership is found to exist, and let's assume that there is a net asset value of that business that is conducted by the partnership. The portion that is your client's portion of that partnership would then be an asset in her estate.
Yes.
And that would then need to be taken into account in calculating or in determining whether there has been an accrual in the plaintiff's estate which is either greater than or less than the accrual that occurs in your client's estate, the defendant's estate.
Yes.
How does that impact upon the accrual claim that your client has?
Well, it depends. If
I know that we don't know, I mean, the trial court will determine the amounts, but does it not mean that you either do not or do have an accrual claim depending upon the determination of the partnership, or the termination of the partnership?
If I may ask your lordship to just rephrase that question, I'm not following you.
No. In other words, and I accept this. We don't know what the position is, but you don't have. We don't know whether there will be. Let's assume for the moment the partnership. We don't know whether there will be a net asset value, and to what extent the partners would join in sharing that profit.
Yes.
But what we do know from this formulation is that whatever accrues to the trust from the partnership will not be an asset in the estate of the plaintiff.
No, it will be an asset hopefully an asset in the estate of the defendant. But your lordship would also notice that there are various loan accounts in the trust. So that will then fall on behalf of the plaintiff, and that will then be regarded as the normal practice, not because of the joinder, as either an asset or as a liability in his estate.
Yes, as I read the financial statements presently, and they may not be the, perhaps I'm incorrect, it appears to me that on the loan account, there is a, that appears to be a liability. But that's another, for another matter. All I'm suggesting is that the dissolution of the partnership, the effect of the dissolution of the partnership that your client alleges will be that whatever portion of that partnership is not that of the defendant, it will be that of the trust. In other words, not that of the plaintiff.
Yeah.
How does that impact upon the allegation that there is an accrual?
That is where I come back again. If the court finds that there is an accrual in my client's estate, that she needs to share, as alleged by the plaintiff, that she needs to share with the plaintiff, as a consequence of either the assets or the share in the partnership, then obviously that's going to have an influence on her maintenance claim. If she needs to share her accrual with the plaintiff as a consequence of the divorce, then obviously she's going to have a bigger maintenance claim against the plaintiff in the divorce, which is going to go back again to the accrual. What is the accrual? What is the value of the accrual? The determination of the accrual? Is there a value in the partnership? If not, what are the parties' respective shares in that partnership, if any? And also, what is the plaintiff's accrual in his estate?
All right, fine. I understand that argument. Thank you. Could I just ask you then that, just so that I'm clear, the basis upon which it is alleged that there is a partnership is not that set out in MAC4, which was the annexure to the founding affidavit.
No, it's no longer annexure MAC4, and the reason being because it does not comply with Rule 18 of the Rules of Court, and also he did not list, according to the respondents, sufficiently how the parties are going to be cited when they are joined as trustees of the trust in the divorce action. So that was the first part of why the reason for the change in MAC 9, and then claim 2 has been formulated in MAC 9 to bring it in compliance with the Trust Property Control Act. And also Rule 18 of the Rules of Law.
Yes, but claim 2 is now formulated, is premised upon a different set of factual allegations to that which is set out in the annexure to the founding affidavit.
Not really, because
it's an entirely different partnership, is it not?
It's the allegations made in MAC 4 was the same, that there was a partnership.
But between who?
She said initially between her husband, and the trust. Now in MAC 9, she says the partnership is between her and the trust, and her husband being the managing director and representative of the trust.
No.
So that is the difference.
Sorry, did I understand you to say that in MAC 4, she alleges that the partnership was between her husband, and the trust?
Yes, that was the intention of MAC 4.
But it plainly doesn't read like that.
Yes, it doesn't read like that.
Well, it indicates, in fact, that the partnership, upon any reading of MAC 4, that the partnership was between her and her husband.
Yes. And
that's what MAC 4 alleges.
And the trust.
No, but it doesn't say and the trust. Where does it say and the trust?
That's the reason why MAC 4 was changed, because it was supposed to say and the trust. If you read the founding affidavit, your lordship would notice that she says that there's a partnership between her and the trust and her husband. But she didn't make that allegations in MAC 4.
But sorry,
she
could
only
you?
made the allegation in the founding affidavit to say that there was a partnership. If I can refer your lordship to that.
Yes, could you take me to MAC 4 where that allegation is made? Because I don't read it.
No, it's not made in MAC 4. That's the reason.
Yes, no, I understand that.
It was made in the founding affidavit, but not in MAC 4.
Where in the founding affidavit is that allegation made? That it is that it was a three-way partnership.
In paragraph 16, she said that.
Sorry, just let me get there, please. Paragraph 16.
Page 10.
Page 10. Yes.
She says during March 2001, she and the plaintiff entered into an oral agreement of partnership known as the Graham Clark Electrical Trust.
Okay, yes, just known as the trust. Yes, thank you.
My apologies.
No, fine. Quite okay.
Undertaking that she and the plaintiff will bring into the partnership money, labor, and skill, and then to carry on business for the joint benefit of them, with the common object of making a profit from the partnership's business.
Yeah. But if you look at paragraph 16.2, there the allegation is made that the trust, that the profit and loss of the partnership be divided between the plaintiff and the defendant as follows, with the plaintiff to get 65% and the defendant to get 35%. Now, by my calculation, that makes 100%. And that leaves no room for a third party to form part of that partnership. Surely.
I misunderstood your lordship. My apologies. I misunderstood the argument that your lordship raised with me. What I'm saying is that initially she and the husband within the trust had a partnership.
No. Yes.
Paragraph 16. That's my version.
Yes, but it was a
in the
It was
trust.
a partnership trading as the trust.
Yes, yes,
That's
that's
what
correct.
paragraph 16.1 says.
Yes, that's correct. My apologies.
Yes. So it wasn't a three-way partnership.
No, it was not a freeway partnership.
No.
My apologies. I misunderstood.
All right.
Or
Thank
I
you.
didn't.
But the factual allegation that's now made in reply is that it was not a partnership between the plaintiff and the defendant. It was a partnership between the defendant and the trust.
With the plaintiff representing the trust.
Yes, no, that would necessarily be so. The defendant was also an authorized representative of the trust. I understand that. So it's acting in a representative, but the fact remains that the allegation is that it's a different partnership. There are different parties to this partnership.
Yes.
Not so.
Yes, I must concede that.
Yes. And that raises, of course, the argument, and we'll hear about in due course, and perhaps you can indicate what your view is, that now we have an entirely different case made out in reply to that which was made out in the founding affidavit.
Which I do not agree with. And the reason being, in the founding affidavit, the purpose of launching the application was to join the trust. And the reason why the trust ought to be joined was there was a partnership which involved the trust's assets and liabilities. The formulation of MAC 4 and MAC 9, if we, for example, did not ask in the original notice of motion also for the amendment of the pleadings, then your lordship would only have been confronted with the allegations without MAC 4 and without MAC 9, with the allegations that there's a partnership and the reasons for the partnership. The reasons for the partnership is substantially the same. The parties during March 2001 entered into a partnership agreement. And the partners of the partnership was, first of all, the wife and then the husband in his capacity as representative of the managing director of the trust. That's MAC 9.
Yes, that's the position now adopted.
Yeah.
In reply.
But that's irrelevant if one considers whether there ought to be a joinder of the trust. With all due respect, why I'm saying it's irrelevant is because the case brought to the court was join the trust because there is a partnership between me and an entity that's involving the trust's assets and liabilities. She said, first of all, she said it was the husband. And then she said in the replying affidavit, no, it was not the husband. The husband represented the trust. He was the managing director and in his representative capacity. But it's not necessary for your lordship to decide on the issue of joinder of the trust, whether the amendment should be granted in a MAC 9 or not. The reason being, the case was from the onset, we need to join the trust because there is a partnership that's going to affect the assets and liabilities of the trust. And the court cannot make an order against in the accrual in the divorce action without affecting the assets and liabilities of the trust. And that was the case throughout. Irrespective of the wording of MAC 4 and irrespective of the wording of MAC 9.
So would the position be different if we were not dealing with the trust?
In what
sense? If it was a third party, entirely unrelated to the plaintiff.
No, but you cannot make that analogy. The reason being because the plaintiff was part and parcel of all of this. It cannot be, you cannot now decide, well, the plaintiff is not part of this because suddenly he's is out of the picture and referring it to a normal third party. For example, let's say my attorney, Anthony Gooden, Mrs. Anthony Gooden, was in partnership with the defendant. That's not the same as the second defendant being Mr. C, representing the trust, of who he is the sole beneficiary also, and of being the managing director of the trust. You cannot compare it with a normal third party. Not in this scenario.
Why not?
The reason being because the managing director of the trust used the trust to pay various expenses of both parties, of himself and also of the applicant throughout the marriage.
Yes.
And in that sense, that created the partnership between the applicant and the trust.
Sorry, I misunderstood that submission. I thought that there was an agreement which formed the trust.
There was an agreement.
But now your submission now seems to be based on the fact that there was a course of conduct and that gave rise to the partnership. Did I misunderstand your submission?
No, Your Lordship would notice that in paragraph 13 of the founding affidavit, and that's why I started with that, she said that during the marriage, the plaintiff used the trust as a vehicle to finance his personal estate and to pay the personal expenses of the parties.
Yes. How does that relate to the fact that there was a partnership to conduct the business that the trust conducts?
No, she said that during the marriage, the plaintiff used the trust, Mr. C used the trust to pay for his personal expenses, but also to pay for the party's personal expenses through the trust. Yes. A third party cannot be compared to this scenario because a third party is not going to be, Mr. C would not have been able to use a third party to pay for all his expenses and for the applicant's expenses through the third party's account. That's the reason why I say Your Lordship cannot compare a normal third party to the trust as the vehicle.
Yes, but how does that bear upon whether or not there is a partnership?
Your Lordship doesn't need to decide whether there is a partnership.
No, I accept that. I accept that I don't need to.
And Your Lordship should not even go into that investigation. If the allegation is made that there's a partnership that she intends to prove at the trial, and it's going to affect the accrual and the maintenance of the defendant, then the trust ought to be joined because its assets and liabilities are going to be affected by the accrual claim and by the maintenance claim. That's the end of the exercise.
Does that not apply? Does that argument, I hear the sort of essential principle argument that you advance, but does that then not apply in relation to a third party where there might be a partnership?
If the third party's rights is going to be affected in the accrual and in the maintenance, then obviously that third party must also be joined. But I cannot for the life of me...
In every divorce proceeding?
No, I cannot for the life of me think of a divorce matter where a third party would be joined because his assets and liabilities are going to be affected, unless there was a partnership and as a consequence of the divorce, that partnership cannot continue.
Yes, but
that's the reason why...
Partnership is not... Sorry to interrupt you. The partnership is not a partnership between the plaintiff and the defendant. What you're alleging is a partnership with a third party. And because of the existence of that partnership, and the existence of that partnership may impact upon the calculation of the value of the estate of the defendant, you're suggesting that that party, a third party, must be joined in these divorce proceedings. And I'm wanting to understand the principled basis upon which you make that submission?
Your Lordship is making it too simplistic because it's not like a third party. The reason why I'm saying that is if your Lordship consider that here is a husband and a wife. The wife is in partnership with the husband's business. She doesn't want to continue with that partnership as a consequence of the divorce. And she wants a dissolution of the partnership, which will have then, as a result, and I'm not going to repeat myself, an effect on the accrual and the maintenance, but that's different from my client having a partnership with an unrelated third party where she can continue after date of divorce with a partnership and with the business of that partnership, because the third party is not affected by the divorce. The third party is not the husband who she needs to work with. It's not the husband who she wants to divorce from. She says in a filing affidavit, in a replying affidavit, I do not wish to continue with the partnership as a consequence of the divorce. The husband is the managing director of the business of this partnership. I don't want to continue with the business of the partnership because I'm divorcing the managing director of the partnership. If there was another third party in this matter, then that third party and she would have continued with the trust, with the business as partnership, because that third party is not the husband she's been married to. That third party is not asking her for the divorce. That third party is not refusing to pay her maintenance in the divorce. So that is the reason why your Lordship is making it too simplistic to say that, let's just say the trust is a third party. The trust can never be regarded in these circumstances as a mere third party, because the soul of the partnership is being divided as a consequence of the divorce. The husband is the MD and the business of the trust. He is divorcing the partner of the trust.
Yes. All right, I hear your submission. Thank you.
And in that sense, I would submit that this matter cannot be compared to an unrelated third party. And in those circumstances, she says, and I can just read paragraph 16.8 to confirm that, as a consequence of the divorce, I no longer wish to continue with the partnership. And she says she's asking for the dissolution of the partnership on date of divorce, alternatively on a date as agreed between the parties.
Yes.
And she then says that's the reason why the trust ought to be joined, because I'm not going to continue after date of divorce. I'm not going to continue with this partnership. So all in all, the business of the partnership is going to end on date of divorce. The third party's business is not going to end on date of divorce, because a third party is going to be not affected by a divorce order.
Yes. Yes, thank you. The partnership could terminate before the date of divorce, though, not so.
She said, or as a date as agreed between the parties, alternatively at a date as agreed between the parties.
Yes. Notionally, the defendant could separately, I'm not suggesting this, but notionally, separately, she could terminate the partnership with the separate entity.
She can terminate the partnership with a separate entity, and that's where I started with my argument, but then it's going to have two different courts of actions. And again, the accrual in the divorce action and the maintenance claim will have to stand over until the dissolution of the partnership happened. But
that takes me back, and I don't think we need to go back into that debate, but it does raise the question as to the relief specifically sought against the trust.
As I've indicated to your lordship, paragraph 11 of claim of the relief sought under claim 2, there must be actually an 11A to say dissolution of the partnership, and 11B that the receiver then take control of the books and statement and abatement of the account of the partnership. In MAC 9, there must be a request also made for the dissolution of the partnership.
Which means really that as I understand it now, in reconvention, what you are now suggesting is that the defendant has a cause of action against the trust, which is a claim in partnership, which is really separate from the divorce action, that will determine what assets are in her estate. And so in reconvention, that issue would need to be determined first before the claim in convention can be finalized.
Yes. But your lordship must also bear in mind, it's not only the accrual that's at issue here, it's also the maintenance claim, which is also a claim in reconvention. But the maintenance claim the accrual will affect the maintenance claim.
Yes, well, whether she has a claim for maintenance or not will be dependent upon the determination of the value of her estate. Not so. I mean, you conceded that obviously necessarily be the case. Yes.
Yeah.
Yes, thank you.
I don't know if your lordship wants me to address you on the amendment or first the striking out, or can we deal with everything in once?
Yes, I think that given the nature of the various applications that have arisen, I think it's prudent simply to address me on all of the aspects that I would need to be decided, rather than separately. So I'm in your hands as to which particular aspect you wish to address me on.
Then I'm just going to continue with my argument, and your lordship
Certainly.
can interrupt at your convenience. In respect of before I deal with the amendment, the application to strike certain allegations in the replying affidavit, your lordship would notice in the supplementary heads of argument, the issue has been addressed, and because it was not raised in the heads of argument because of the typing error that was in the notice to strike, your lordship would find that from paragraph 2 in my supplementary heads of argument.
Yes.
Now, the test that your lordship needs to decide on whether the application to strike ought to be allowed or not is whether there is any prejudice for the respondent when the application to strike is launched. And because the test is in 2 aspects. First of all, it must be either scandalous, vexatious, and then also in terms of the common law, new matter. But then also, the court must be satisfied if such matter is not struck out, the party seeking such relief would be prejudiced. In other words, would the plaintiff or the respondent be prejudiced if your lordship is not striking out those allegations made in the various paragraphs as listed in the notice to strike? And the submission is made, no, the respondent did not satisfy the test and the respondent will not be prejudiced. The reason being, the respondent considered, first of all, the replying affidavit and specifically the contents of Annexure X and Annexure MAC 9 and the allegations made in support of those annexures. And having considered that, the respondent on the 13th of September filed his notice of objection in terms of Rule 28(3) of the Rules of Court. I will deal with the issue of condemnation and the Rule 30 application separately. But let's say, for example, it was brought within time. and it was brought within the 10-day period as supposed to in terms of Rule 28.3, then the respondent would not have been prejudiced because he would have made his objections known, and then the applicant had two options, either to abandon the application or proceed with the application to amend before the court. And in that sense, because the respondent exercised his remedy in terms of Section 28, he cannot then also go to court and say, but I also want a second bite at the cherry, and in terms of Section 615, I also want to strike out those allegations referring to Annexure MAC 9 and Annexure X, because he was not prejudiced. He had an opportunity to raise his objections, which he did. If the objections are brought out of time, like it was in this matter, then still the respondent is not without relief and not without remedy, because the respondent can, in terms of Rule 27.1 of the Rules of Court, ask for condonation for the non-compliance of Rule 28.3. And then his objections, if condonation is granted, would have stand before court, and your lordship would have considered those objections. And your lordship would not have considered a Rule 615 application to strike. The reason why the application to strike was brought was because the respondent realized, having received the applicant's replying affidavit in the Rule 30 application, that the applicant actually had valid reasons to bring a Rule 30 application. And now suddenly, because the shoe pinches, the respondent wants to strike those allegations in annexure, referring to Annexure MAC 9 and Annexure X in the replying affidavit, because the respondent fears that the objection, which was brought on the 13th of September, is not going to stand water. And in those circumstances, he didn't satisfy the test of being prejudiced. And he cannot tell your lordship that he was prejudiced and he's going to be prejudiced, because the respondent can still bring an application for condonation to ask that his objections be considered, the ones of the 13th of September. Alternatively, what this court can do is your lordship can say that the joinder of the trust is ordered and the applicant must serve a notice of intention to amend within 10 days. And then the respondent will also have the right to object to that, because of the history and because your lordship is aware that the respondent wants to object to the specifically now to the contents of Annexure MAC 9. The fact of the matter is that if the respondent does not satisfy the test of being suffering prejudice, then your lordship cannot order that those averments in the replying affidavit referring to Annexure X and Annexure MAC 9 should be struck in terms of 615, because the respondent did not satisfy the test. That's the long and the short of the, and your lordship will see the authority that I'm relying on in my supplementary heads of argument.
Thank you.
That's also been dealt with in paragraph 17 of my heads of argument, where I deal with new case under reply, and also then I'm just furthering that argument in paragraph 25 of my supplementary heads of argument. Another allegation in the respondent's heads of argument in respect of the amendment, if I can move on to another point, my lord.
Yes, of course.
The other allegation in terms of the amendment, your lordship would find in my supplementary heads of argument in paragraph 28 onwards, I'm dealing with the contents of paragraphs 42 and 52 of the heads of argument of the respondent. And in that part of my heads, your lordship would notice that the applicant says that the respondent says that the applicant did not comply with Rule 28.5 by serving her amended papers on the respondent after the 10-day period as contemplated in Rule 28.1 and 28.3. Now, of course, the applicant could not serve amended pages on the respondent after the 10-day period after you received the Annexure MAC9. The reason being, the applicant is asking, first of all, for the joinder of the trust, and as a consequence of the joinder asset of the trust, she's asking to amend the pleadings to effect that joinder. The applicant, if she served her amended pages after the 10-day period lapsed, as contemplated in Section 28, would have been, she would have could have been an issue raised of non-joinder or misjoinder because the trust has not been joined, and the trust is cited in the notice of amendment and proposed in Annexure MAC9. And the notice of motion specifically says that the applicant is going to request the court for allowing the amendment. So in that sense, the applicant would have put the cart before the horse if she served the amended pages as contemplated in MAC9 after the 10-day period. She first must have the consent and the order of court to join the trust before she can cite parties in a counterclaim as anticipated in MAC9. So that point, if I understood the point made by the respondent in his heads of argument, are nonsensical I submit it's nonsensical, because the applicant can never serve her amended Annexure MAC9 pages on the respondent before the trust is joined.
Yes.
Then, in respect of the contents of Annexure MAC9, if the court is not satisfied that the amendment sought should be granted because it's, as contended by the respondent in his heads of argument, execrable, your lordship can then still continue to join the trust. It's not necessary for your lordship to amend also the pleadings as requested in Annexure MAC9. The applicant can then, having been granted the order to join the trust, served a notice of amendment on the respondent, where she then indicates how she intends to effect the amendment. The reason why the amendment was sought with the joinder is to explain to the court why the joinder is necessary. But it's not necessary for your lordship, when ordering the joinder, to also order the amendment. I've made that point in my heads of argument.
Yes.
Then, in respect of the application, the Rule 30 application, your lordship would notice that the respondent says that the applicant was out of time with the application after she served the 32B notice on the respondent to say that the notice of objection was served out of time. The respondent then said, well, the applicant was supposed to, within 15 days thereafter, serve the application. Well, that's incorrect. She first must allow within 32B 10 days to lapse before she can bring her application in terms of Section 30, because the respondent has, in terms of the 32B notice, 10 days to either withdraw his irregular step or to follow through on it. He didn't withdraw in those 10 days his irregular step. Thereafter, in terms of 31, she then has the right to bring an application in terms of Rule 30 within 15 days thereafter. And the applicant brought her application on day 15, served it and filed it on day 15, the Rule 30 application. So the applicant was within time with the application in terms of Rule 30. It's common cause that the respondent was out of time with his objections in terms of Rule 28.3. He served it a month later instead of within 10 days without a condemnation application, and the applicant is in those circumstances entitled to ask that the application of the notice of objection be set aside as an irregular step, dated 13 September 2019. The respondent says that in one paragraph that if he's out of time, then he's asking for condonation for the non-compliance of Rule 28. Well, if you ask for condonation for the non-compliance of the rule, you need to satisfy Rule 27. And in my heads of argument, I addressed that issue. And I said that the respondent did not request condonation, and he did not satisfy Rule 27 to say why he was out of time and all the requirements of Rule 27 to allow your lordship the discretion and satisfy your lordship's discretion as to why condonation should be granted for the non-compliance. It's not for the mere asking of a respondent to say, well, if I'm out of time, then just grant me the condonation. He must explain why he was out of time, especially under circumstances where he was made aware by way of a notice in terms of Rule 32B that his step is irregular and that he must cure that irregular step. And yet he decided and elected not to do anything about it. So in those circumstances, it's my submission that the applicant is successful in a Rule 31 application and that the application to strike ought to be, the application that the respondent's notice dated 13 September 2019 is an irregular step, that your lordship should grant that order. The lordship would notice that the application in terms of Rule 30 was brought under a different index, and it again starts from page 1 of the notice of motion, and the applicant is requesting relief in terms of prayers 1 and 2 of that notice of motion, which your lordship would find on page 1. The notice of motion is dated 25 October 2019.
Thank you.
I've addressed your lordship on the joinery issue. I've addressed your lordship on the application to strike. I've also addressed your lordship on the Rule 30 application. I just want to see if there's anything else that I need to. The amendment. I think your lordship and I have discussed the amendment. The applicant afforded the respondent sufficient time to consider the amended notice of motion. And your lordship would notice that if you want to amend a notice of motion, you need to do that in terms of Rule 28. The applicant served a replying affidavit. She allowed the respondent 10 days to consider the notice of motion. And it's evident that the respondent considered the contents of Annexure X, the amended notice of motion. And the applicant is, if your lordship is of the opinion that the notice of objection of the respondent of the 13th of September is an irregular step, then your lordship can order that the notice of motion as contemplated in Annexure X be amended, and then your lordship can grant certain relief in Annexure X. If I can then turn your lordship's attention to Annexure X. Your lordship will find Annexure X on page 157 of the paginated papers of the main application, and your lordship will see that the applicant requests that Pre 1 of the original notice of motion be substituted with Pre 2 herein. Now, Pre 2 says that the second and third respondents be joined as the second and third defendants to the divorce action. So that is the relief that the applicant is still persisting with, Pre 2. And then that the cost of the joinder application be ordered to be cost in the course. That's Pre 3. And then Pre 4, condonation, insofar as it is relevant for the non-compliance of the rules for the notice of motion. But then she's also requesting, if I can turn your direction again to 1.2, substituting Annexure MAC 4 in Prayers 4 and 5 of the notice of motion with Annexure MAC 9, and that has bearing on Pre 5, 6, 7, 8, and 9 of the amended notice of motion on page 159. The applicant is requesting that leave be granted to amend her pleadings in terms of Annexure MAC 9 in Prayers 5 and 6, and then also that the respondents be ordered to have time to consider that and to file their plea and their replication if the amendment is granted. If your lordship is not amenable to grant the amendment, then your lordship can, I will address your lordship on why your lordship should grant the amendment, but if your lordship is not amenable to grant the amendment, then press 5 and 6 and 7 and 8 and 9 of the notice of motion can then be ignored by the court, because that is having effect on the amendment.
Yes.
And then your lordship will only grant an order in terms of the amended notice of motion in terms of press 2 and 3 and 4 on page 158. However, if your lordship is amenable to grant the amendment, then your lordship must also grant press 5, 6, 7, 8 and 9. Now, I've indicated to your lordship that there is a flaw in Annexure MAC 9, where there must be a dissolution, a request also made in the relief sought for the dissolution of the trust. Well, your lordship can either grant that now, alternatively, your lordship can say that the applicant has 10 days from date of order, alternatively 15 days from date of order, to amend her pleadings. And then that defect will be cured within that 10 or 15 days. But it's subject to your lordship's approval.
Yes.
My lord, insofar as the case for the applicant, from the onset, the case of the applicant was join the trust. That is the application that your lordship is tasked with, and the respondents also make that statement in the heads of argument. Everything that happened after that is a consequence of the joinder. So your lordship was faced with a joinder application. If the applicant is successful in the joinder application, then the applicant requests in the replying affidavit that the respondent be ordered to pay the costs up until from date of having received the replying affidavit. However, I would make the submission that your lordship should make the order in terms of pref 3 of the amended notice of motion that costs of the joint application be ordered to be cost in the divorce action. Because if the applicant, albeit she was successful with the joint application and it happens in the divorce action that she is not successfully with the claim against the trust as a consequence of the joinder, then the cost of the joinder application should then form part of those costs. That is the case law that I've also read, and that's a normal course that courts adopt in matters similar to this. The respondent is requesting that the applicant's joint application at the applicant's application for amendment be dismissed with costs. The application for amendment, as I've indicated to your lordship, is a consequence of the joint application, and the applicant is in any event tendering the wasted costs occasioned by the amendment. The issue that your lordship had to decide primarily was the joinder of the trust. And in those circumstances, I would say that the application for amendment should not be ordered against any of the parties if your lordship is not amenable to grant the amendment, because the amendment was not the main reason why the parties are before court. Even if the amendment was not brought to your lordship's attention, the joint application was before your lordship, and the joint application is the issue that your lordship must first exercise. Whether the amendment is going to be proved and good in law, that is to be decided in the end by the trial court. And that will also cure the issue of the respondents wanting to object to the contents of Annexure MAC 9 as they intended to do in September 2019. My lord, I think those are the issues that I had to address with your lordship. Your lordship has the red limited authorities that I've mentioned to your lordship, and the reason why I referred your lordship to the supply links in those is normally what I would have done is I would have compiled a bundle of authorities for your lordship to hand up, where authorities only came after we've we've handed our heads to the court in order to make it more convenient for Your Lordship, but because of the lockdown situation, I could not do that, and Your Lordship would find it convenient to also find the authorities on those lists as listed there. And I've checked it. If you click on the link, then it actually goes through to the correct authority.
Thank you.
My Lord, as I mentioned from the onset, this matter is very similar to the matter of B against B, and Your Lordship can exercise Your Lordship discretion on the same premise as that was in B against B, and join the order the joint of the trust as requested in the amended notice of motion. May I take a quick introduction from my attorney?
Please do. Thank you.
No further submissions, my Lord, unless there's anything else that Your Lordship wants me to address Your Lordship on.
Thank you, Ms. Veldsman, for your address. I do have your heads of argument, and we'll consider those in due course as well. Thank you. Thank you, Mr. Nepgen.
Sorry, thank you, my Lord. Am I unmuted?
Yes, you are.
My Lord, just perhaps I should start on the principal point we raised in our heads of argument, and that is that we've set out, Your Lordship would have seen how we believe the matter can conveniently be approached, and the premise for that is that we believe the joinder itself is fundamentally flawed and incompetent. Your Lordship, in assessing that, doesn't have to get involved in the merits as they may be in respect of the joinder of the trust. Your Lordship also needn't concern yourself whether the joinder and or amendment raised in reply will be allowed to be considered, or that one in the founding affidavit. Because as we see it, my Lord, the joinder is sought on exactly the same basis. And I'm not talking about the different partnerships, I'm talking about the fact that what the defendant seeks in this matter is to join the trustees as second and third defendants. Your Lordship touched on that with my learned friend. I didn't understand you to answer Your Lordship's quick concerns in that regard, so I'm going to address Your Lordship just further there. My Lord, if we look at and perhaps I've said the basis is the same in the founding papers and reply, and perhaps I'm being overly generous with the founding papers, because if Your Lordship looks at MAC 4, that's the annexure containing the First Amendment, it seems from MAC 4 that was a joinder in spirit only, my Lord. There are multiple references to the trust in MAC 4, but there's no actual relief sought against the trust. There's no citation of the trustees as defendants or as any other party. And it simply seems that there was an allegation of this partnership, and the only relief sought in MAC 4 was sought against the plaintiff. My Lord, for the purposes of the point I'm trying to make, we're prepared to accept that there, at least, it was envisaged that the trustees would be joined as second and third defendants. And perhaps just to show Your Lordship in MAC 4 where we can find that, if Your Lordship turns to page, it starts on page 959, my Lord. Your Lordship would see, you can just touch on the allegations. If Your Lordship goes to page 61, so it's page 3 of the notice to amend, Your Lordship will see there under the paragraph 4.5, there's a reference to the business of the trust. There's reference to the trust's business. Your Lordship would see over the page, the 4th page, there's again reference to the trust and the trust business. Over the page, page 5 of the amendment, there's then an allegation in the paragraph 13 there that the first defendant claims the proceeds from the dissolution of the partnership ought to be regarded as an asset or liability in the parties' respective estates. And then the counterclaim relief then comes in, and Your Lordship would see in the relief, if we turn forward to page 7 of that notice to amend, the only relief seemingly sought is against the plaintiff, if Your Lordship sees there in paragraph 11 under claim 2. So there's joinder in spirit, as I said. There's no actual leave sought to join the trustees and to refer to them in the proceedings as a party. The Lordship would see the only references at the bottom of that page 7, where there's an indication that the defendant intends amending the heading in the plea and counterclaim by joining the trustees of the trust as the second and third defendants. And your Lordship would have seen from MAC 9, which is the second amendment there. Also, your Lordship would note, if we turn to MAC 9, that the nature of the joinder that is sought there also is to join the trustees as second and third defendants. If I can just take your Lordship to page 151, so it's page 2 of that notice of intention to amend. And there your Lordship see at the top of the page, it says the plaintiff joined as trustee and is of the trust and is cited as the second defendant as a consequence of the joinder of the trust. And then in 2.3, the same is repeated in respect of the defendant, that she would be cited as the third defendant as a consequence of the joinder of the trust. And if your Lordship then pages to page 4 of that notice of intention to amend, it refers to the changes to the counterclaim, and the first paragraph there, the parties in reconvention are cited as in convention. So the effect of that, my Lord, is that the defendant brings a joinder application to join the trustees against which we know she wants to claim relief, and she joins them and seeks to join them as co-defendants. Plaintiff, as your Lordship's identified, has no list against the trust, and plaintiff has no interest in any claim against the trust. So the only conceivable basis that the defendant can join the trustees or the trust would be as defendants to her counterclaim defendants in reconvention. There's simply no other procedural mechanism in terms of which the trustees could be joined. So instead of asking for that, the applicant seeks to join the trustees as defendants in convention. So the effect of that, my Lord, is that they're effectively co-plaintiffs in reconvention. Your Lordship, I've taken your Lordship to what's said in MAC 4, I've taken your Lordship to what's said in MAC 9, and what then follows is as co-defendants, the defendant then seeks to pursue a claim against her co-defendants. My Lord, that is procedurally and legally flawed. There is no basis in our rules or in the nature of our process for a defendant to have a claim against another defendant. There is just no scope for that. If your Lordship just steps back and imagines what one would be left with this joinder that is sought, is that you would be left with a plaintiff, you'd be left with 3 defendants, one defendant would be counterclaiming against the plaintiff and then have a separate claim against 2 of the other defendants. It's simply untenable. And we submit to your Lordship that is really the end of it, because if the whole entire basis upon which the trustees are sought to be joined is not a legal possibility, which it isn't, then that is the end of the application. And your Lordship will have noted from the papers and the heads of argument filed on behalf of the respondents that this was pointed out to the applicant right at the outset when the respondents filed their answering papers. It was made very clear in the answering affidavit that you cannot join the trustees as co-defendants. We've set it out, your Lordship. If I can just take your Lordship to starting at page 118 of the answering affidavit. Your Lordship, that's paragraph 6. If we have the same paginated papers, it says the notice of motion itself does not identify in which capacity, i.e. co-plaintiffs, co-defendants in convention or co-defendants in reconvention, the trustees are sought to be joined, and merely in paragraph 1 seeks their joinder. Founding affidavit in paragraphs 4.2 and 5 thereof suggests that if the respondent is joined as a trustee, he will be cited as the second defendant, and the applicant as a trustee will be cited as the third defendant. The notice of intention to amend MAC 4 does not reflect the citation of the trustees as either defendants in convention or in reconvention, merely seeks to amend the heading in paragraph 10 of the amendment which I took your lordship to. No relief is sought against the trustees in the purported amendment, and the joinder is motivated by only the following amendment. Its assets, that's the trust and liabilities, are going to be affected by the outcome of claim 2 of the first defendant's counterclaim. And then we've made it absolutely clear at the bottom in paragraph 7, if your lordship sees right at the bottom, the only basis upon which the trustees could thus be joined would be as defendants in reconvention. So the applicant's attention is drawn pertinently to the fact that the basis upon which she seeks to join the trustees is not competent in law. And I submit your lordship would have little difficulty in finding that what is sought, and I see my learned friends trying to shift about and say, well, we've always just sought the joinder, so your lordship can go and order the joinder. You can do that, and then we'll sort out the amendment and the basis upon which we want to join them later. But just join the trust, and then we'll resolve all these difficulties later. Well, with respect, my lord, what is sought here is the joinder of the trust and trustees as defendants. That is not legally permissible, and then that is the end of the matter. As we've submitted, my lord, is we believe that then everything follows from there. If it can't be sustained, your lordship doesn't have to debate all these other questions of reply, what can and what can't be allowed, the application to strike, the irregular proceeding, and then that all becomes academic in relation to the main application, except insofar as your lordship might want to consider it separately in respect of costs. Our primary submission, my lord, is that all that has flowed from the pursuit by the applicant of this application that just could never succeed on many bases, but primarily on the basis that you cannot join trustees against whom you want to claim as a co-defendant. So everything that's followed upon that is because of the pursuit of this. Was pointed out to the applicant as soon as it could be pointed out, and despite this, we now have a rip-roaring Rule 30 application with all sorts of allegations in it, applications to strike, applications for condemnation, and all sorts which have been forced by the conduct of the applicant. So we say, my lord, that firstly, your lordship, if your lordship's with us on the first point, which we submit your lordship, should be that your lordship will just let the other costs of the other aspects follow the costs of the main application. We would seek your lordship to dismiss the application simply on that basis, and the cost to include any costs associated with the Rule 30 and the application to strike and whatever else there might be. If your lordship's not with me on that, my lord, then of course we need to consider the other issues. Perhaps firstly, it's convenient to consider the application to strike. My lord, the principal argument here is that not only has the applicant introduced a new cause of action, as your lordship points out, the applicant has replaced the existing cause of action with this new cause of action in reply. So the case effectively is sought to be made solely in the replying affidavit. The applicant seems to submit, or my learned friend seems to submit to your lordship that, well, we've always wanted a joinder, so this is not really a new cause of action. My lord, with respect, that's misguided. The joinder is not the cause of action. The basis upon which the joinder is sought is the cause of action. As your lordship's quite correctly pointed out, what is sought as the basis of the joinder, or what's put forward as the basis of the joinder in the founding affidavit, is a partnership between the plaintiff and the defendant in respect of the business of the trust, not a partnership between the plaintiff and the defendant and the trust, as was suggested momentarily to your lordship. What is then put forward in reply is an entirely different legal relationship. Again, I don't agree with my learned friend's interpretation of their own or the applicant's own papers. What is set out in reply is a partnership between the defendant and the trust, and no one else. It's not set out to be a partnership between the defendant and the trust and the plaintiff. And your lordship took and asked my learned friend to take your lordship to the relevant allegations in the replying affidavit in Mac 9, which supported a partnership involving the plaintiff, and there are no such allegations. The suggestion that was made to your learned friend, to your lordship by my learned friend, that your lordship can or should read the allegation that the plaintiff, in his representative capacity as managing director of the trust business, somehow becomes a partner in the partnership and will have an interest in the dissolution of the partnership, if ever that would occur, my lord, is with respect, there's no foundation for that. The allegations are, and I'll take your lordship to that the agreement, as your lordship pointed out, if I take your lordship to page 152, my lord, it's Mac, so we're looking at Mac 9, paragraph 6.2.2, so the allegation there, the first defendant pleads that the business of the GCE trust was conducted as a partnership between the first defendant and the trust, duly represented by the second and third defendants in their capacities as trustees of the trust. So there's no suggestion that the plaintiff is a partner in that trust. The lordship would see that carries on. If we carry on to the counterclaim, page 4 of that amendment, I'll take your lordship to paragraph, perhaps if your lordship goes on to page 6, paragraph 6, under claim 2, my lord, there's during or about March 2011 at Port Elizabeth, the first defendant personally, and then the trust, duly represented by the second defendant in his capacity as a trust of a trustee, and the third defendant in a capacity as trustee of the trust, entered into an oral and or tacit agreement of partnership. So even in concluding the partnership agreement, it's not just the plaintiff representing the trust, it's both trustees, the plaintiff and the defendant. But the important part, my lord, is that the partnership that's alleged is only between the first defendant and the trust. It's got no, the plaintiff has no interest, as your lordship correctly pointed out. If one looks at the, I don't know if Mac 9 repeats the interest in the partnership. It doesn't seem to, my lord. But if one looks at the relief that is sought on page 158, my lord, under claim 2, as it currently stands, all that's sought is that the first defendant prays for an order against the second and third defendants jointly and separately. But there's no relief sought in respect of the partnership against the plaintiff, quite correctly, because it's not alleged that he was a partner. And then 11, an order directing second and third defendants to render to the first defendant an accountable partnership asset. So, my lord, it's clear, if one has regard to what's put up in reply, that it's an entirely different partnership to that, an entirely distinct legal relationship to that put up in the founding affidavit. And that is the basis upon which the application to strike has been brought. It's not sufficient to say we've always been seeking a joinder of the trust, so therefore you can just ignore the basis upon which we said the trust should be joined. Of course, your lordship must have regard to the basis. If there is no ground for a claim against the trust, well, then the trust can't be joined. Well, that was a fundamental problem with the partnership hypothesized under Mac 4, because in law that could never exist. It's debatable whether the partnership under Mac 9 could ever pass legal scrutiny, but we don't have to consider that, and nor does your lordship at this stage of the proceeding. So, my lord, we've set out some authorities in paragraph 32 of our heads of argument, just dealing with your lordship's and the court's approach to replying matter or striking matter from replying affidavits. And my lord, this is not just new matter. This is a replacement of one cause, the only cause of action, with another cause of action. It's not even introducing a second or a third cause of action to an existing one. It is a whole new case. And if that's the case, my Lord, I'm not aware of any authority where an entire case is made out in reply and allowed to stand. I didn't see my learned friend refer, Your Lordship, to any authority that says that. I'm aware of authority where a new cause of action has been added to existing causes of action, where that is allowed if there's no prejudice. But I'm not aware of a situation that is sought here where you just replace the whole case and make out a new case in reply. The effect of allowing the approach of the respondents or applicant to stand would be that what is set out in the reply becomes the founding affidavit, because it can't stand independently, Mac 9. So the basis upon which the joinder in reply is sought can't stand independently with the founding affidavit, because the founding affidavit postulates a different partnership. The founding affidavit doesn't support a joinder of the trust on the basis of a partnership between the defendant and the trust. It supports a joinder of the trust, or attempts to support, on the basis of a partnership between the plaintiff and the defendant in respect of the trust business. So, my Lord, and as I've said, my Lord, so the effect of that is that the partnership that's introduced in reply, and that in Mac 9 is irreconcilable with what is set out in the founding affidavit, and therefore we submit that it shouldn't be allowed. The first and second defendants in respect of prejudice are clearly prejudiced, my Lord. There's irreconcilable cases in the founding affidavit and reply. The respondents have an election of remedies. They could have applied to court for leave, which is sometimes granted, to file a further set of affidavits, or they could have sought to apply to strike out the allegations, which is what they've done, which is what the respondents have done. There is nothing wrong with the latter. The submission was made in my learned friend's heads that, well, you should have just answered, replied again. Your Lordship knows that's not how it works. There are set rules and sequence of filing papers. You're obliged to set out your case in your founding affidavit, and if you don't set it out in your founding affidavit, there are very limited grounds upon which you will be allowed to supplement or set something new out in reply, and these are not those grounds. My Lord, Your Lordship, I don't have, I'm a bit limited in the case references I could get at home, but I'm aware of a judgment by His Lordship, Mr. Justice Alkema, on appeal van Wingaard versus Grobler, where he dealt with it. It was a magistrate's court matter that went on appeal, where he dealt with parties just filing affidavits out of sequence and the endless, and set out nicely the principles in that matter that apply, which Your Lordship's in any way, no doubt, well acquainted with. So, my Lord, the application to strike identifies, as best we could, the paragraphs relevant to this new case that's set out in reply, and that includes attaching annexure Mac 9, which is the new amendment sought. We submit, my Lord, that there's simply no merit in the argument that the applicant puts up, that the application to strike, if Your Lordship has to go there, should succeed with costs. If Your Lordship finds it's academic, which we believe it is, in any event, Your Lordship will order the costs to be paid by the applicant. My Lord, if Your Lordship's with us on the application to strike, and I've dealt with it this way around because I think then it effectively puts paid to any argument on the Rule 30, because the amendment that's then the subject of Rule 30 is no longer before Your Lordship, and the application itself again becomes absolutely academic, not because of what the respondents did, but because the applicant came and tried to introduce an entirely different basis of joinder in reply. My Lord, I'm going to just address Your Lordship because there are some issues on the Rule 30 application in respect of costs, which I think Your Lordship must have regard to. Learned friends addressed Your Lordship and assumed that there is an irregular step. Perhaps, my Lord, one should start with Annexure X, which I have as my page 160. It starts at page 160. And your Lordship would see there, page 160 has Annexure X. Your Lordship would see over the page, it's headed Amended Notice of Motion. So it's not on the face of it a notice of intention to amend. It then proceeds to say, take notice at the hearing of the application to join the trust, duly represented by plaintiff defendant as trustees. The applicant intends to make application for an order in the following terms. So that seems to be an application for leave to amend. And then in one, it's sought that leave be granted to applicant to amend the notice of motion by doing the following. And then it sets out what one would expect to find in a notice of intention to amend, which you could see there in 1.1, 1.2, and 1.3. And then it carries on under 2, 3, 4, 5, 6, 7, 8, and 9, and 10 to set out what seems to be not, it's not cited as part of paragraph 1, but it seems to be the rest of the notice of motion, if your Lordship has regard to it. So it seems to be in the form of how the amended notice of motion will read at the end of the day. So if we then proceed, your Lordship would see on page 4, it then says, take notice further that you are hereby afforded 10 days to consider the applicant's notice of intention to amend, i.e. Annexure Mac 9 attached to the replying affidavit, as contemplated in Rule 28.1 of the Uniform Rules of Court. If no notice of intention to oppose is given as contemplated in Rule 28.3, then in that event, the applicant will at the hearing move for an amendment as sought in Annexure Mac 9 to the replying affidavit. So they don't even provide in this purported notice to amend the notice of motion a period within which the respondents should record their objection to the amendment to the notice of motion. It's, as your Lordship sees, a mixture and a confusion between a notice of intention to amend and a perfected amended notice of motion, and or a reference to the amendment of Annexure Mac 9. Your Lordship, in those circumstances, we would submit where there is no period within which a party is required to object, that what one would do normally, where the application is going to be heard at the hearing of the matter, is you would object within a reasonable time. And you would object within a reasonable time before the hearing application for leave to amend or whatever this is will be sought at the hearing of the matter. But my Lord, the fun and games don't end there, because what the applicant then does is the applicant says, hey, but look, go to our replying affidavit, and your Lordship will just bear in mind that the Annexure X is exactly what it's stated. It's an annexure to the replying affidavit. So it wasn't filed separately as a notice of intention to amend the notice of motion. It was simply annexed to the replying affidavit in the form that it is. And then if your Lordship pages to, just find the correct page. Well, I think it starts at page 140. That's paragraph 6.8. So this is now the replying affidavit. I'm advised, in order to effect the amendment as requested in Annexure Mac 9, I have to amend the relief sought in the initial notice of motion dated 31 May 2019. I request the notice of motion be amended in terms of Rule 28 of the Uniform Rules of Court as prayed in the amended notice of motion, to which the contents of this replying affidavit serve to confirm hereto attached as Annexure X. And then over the page 6.9, in the premises, I will also seek at the hearing of a condemnation in terms of Rule 27 for the non-compliance of Rule 28.1 by not serving a separate notice of intention to amend the plea and counterclaim. So that's got to do with Mac 9 on the first respondent insofar as condemnation and so on. And then it carries on. However, it is evident from the contents of the amended notice of motion. So it's stated to be an amended notice of motion, Annexure X here too. The first and second respondents are afforded an opportunity of 10 days to consider the amended notice of motion and the contents of Annexure Mac 9. Well, it's not evident from Annexure X that they're afforded that opportunity. But what the applicant does is the applicant says, but we've got to read Annexure X with paragraph 6.8 and 6.9 of the replying affidavit, and within that, your lordship would somehow conjure up magically a notice in terms of Rule 28, which complies with Rule 28. And premised on that, and from the date of service of the replying affidavit, the applicant then says, aha, when there's an objection noted to the notice or whatever Annexure X is, noted, the applicant takes the point, aha, you see, you filed out of time, you only had 10 days. And from there on, it just goes pear-shaped, because then the applicant then launches into a vehement and passionately pursued Rule 30 application, trying to set aside the notice to object to Annexure X. My learned friend keeps submitting to your lordship that your notice of objection applies to MAC 9 and Annexure X. It doesn't. It's only an objection to the attempt, whatever Annexure X is, to amend the notice of motion. And I ask your lordship this, what else were the respondents supposed to do? They're faced with a combination between an application to amend a notice of motion and a notice to amend a notice of motion, which is stated going to be brought at the hearing of the application, which there wasn't even a date for. And then they object to it and they criticize that Rule 30 is launched, and we run into all sorts of papers filed in opposed applications and so on. So, my lord, the principal submission that your lordship now has the facts and the background as to where the notice of objection comes from and what it relates to. It relates only to the effort to amend the notice of motion, and the basis of it is very similar to the application to strike. It's to say, hey, you can't amend the notice of motion to introduce a amendment that is not supported in the founding affidavit. My lord, it's as simple and as clear and one would have thought as obvious as could be, because we all know if the relief you sought in the notice of motion it's not supported by what you set out in the founding affidavit, well, you're not going to get it. And that's the end of the application. That's the nub and heart of the objection. In respect of the Rule 30 application, principally we say we weren't, the respondents weren't out of time. There was no time period set in whatever Annexure X is. And secondly, if your lordship somehow finds that Annexure X and what's set out in the replying affidavit must be construed to be an appropriate notice of motion, then yes, the notice of objection wasn't filed within 10 days when the replying affidavit was received. It was filed, I think, about a month after the replying affidavit was received. But the point we make in our heads, which my learned friend again misconstrues, is not to say you should have perfected an amendment to MAC 9 within 10 days. It's to say if you were applying Rule 28 and we hadn't objected within 10 days when you filed the replying affidavit, you then had 10 days to perfect your amendment. By the time we filed the notice of objection, your 10 days had expired. So if you want to now come ex post facto, which it seems the applicants wants to do, and apply the rules of Rule 28 and the 10 days that apply to noting an objection, well, bad luck for you, because then you also were out of time. And the theme of that is to say, well, actually then, if that's the approach your lordship adopts, then the notice of objection was superfluous, and or in respect of condonation, the applicant could never be prejudiced because their opportunity to amend that in any event lapsed. We know, however, that Annexure X is a strange creature, my lord, and it doesn't follow normal prescripts, and it contends in its preamble to be a application for leave to amend at the hearing. So clearly it wasn't the intention to apply Rule 28 initially, but somehow the applicant thought this is now a grand opportunity to launch Rule 30 proceedings and set aside the notice of objection, seemingly, if I understood my learned friend's heads correctly, on the basis that, well, if we can get rid of the notice of objection, because they're misconstruing it as one to MAC 9, then your lordship will have to grant Mac 9 because there's no objection to it. So therefore we forget that it's a new case made in reply. There's no objection to Mac 9, so your lordship will go and your lordship will simply grant the amendment, and happy days, that's the end of the story. My lord, that's not how it works. We submit, firstly, no irregular step. If your lordship finds, as I've said, the need to consider condemnation, we've set out the grounds upon which we say it's a short period, no prejudice to the applicant. The applicant or the respondents were embarrassed as to how they should actually deal with the creature that is Annexure X, combined with what is said in the replying affidavit, and that is what led to the delay. There can be no suggestion, as I've said to your lordship, of prejudice on the part of the applicant. So if your lordship wants to consider condemnation, we said that there should be. All in all, my lord, insofar as the application is concerned, if your lordship doesn't find it follows the first part, your lordship must find, we would submit then that it should be dismissed, the Rule 30 application with costs. My lord, it's not a application for condemnation where you have to set out a defense to the whole merits of the matter. It's a procedural application for condemnation dealing with non-compliance, if we're favorably considering Annexure X, with a rule requiring filing in 10 days. So it's not one of those cases where you're late to bring a rescission of judgment application and you have to convince the court that if you granted rescission, you actually have a defense to the claim. This is not one of those applications, and insofar as my learned friend's head suggests that it is, we don't agree. My lord, if your lordship looks, if we step back, and I know I've dealt with it on the basis that your lordship can simply, which we submit you can, dismiss the joinder on the point that there's no precedent or scope in procedure for your lordship to allow. If your lordship looks at what I've said, your lordship raised the issues with my learned friend, if your lordship looks at what I've said in respect of the striking out, the different case being made in reply, the fact that in the founding affidavit, the partnership, which is no longer the partnership seemingly pursued in the joinder, the partnership there in any event is something that is unsustainable in law. You can never have a partnership between two individuals in respect of a trust asset. And I understood my learned friend to accept that in her argument. It's simply unsustainable in law. My lord, in respect of the rest, your lordship, if we have Annexure Mac 4 out of the way, all that's left possibly, if your lordship doesn't strike everything in reply, all the new stuff, is Annexure Mac 9. My lord, Mac 9 itself has issues, as your lordship's quite validly pointed out, and it's the point we raised in our heads of argument, is that we don't seek, as the respondents, any relief, or as the plaintiff, any relief against the trust. So if the relationship alleged between the defendant and the trust is simply that, it's a partnership between the defendant and the trust, then how could it conceivably effect or require or justify the joinder of the trust in respect of the issues which my learned friend raises? One is accrual, because what your lordship would know is that if and we don't contend it's an asset in her estate, so why she would want to increase her estate, one does not have clarity on, but if it's an asset in her estate, all she would do in declaring the value of her estate is she would list the value of her partnership interest. As your lordship points out, you don't need to join the trust for that. It doesn't matter that she might be married to the managing director of the business of the trust. Well, that's got nothing to do with whether or not you require the joinder of the trust because you're alleging there is a partnership between yourself and the trust. That is a distinct legal relationship. As your lordship points out, she might not want to continue with it now. She could have terminated it already, or she might have continued with it after the divorce. There's nothing in law which stops her. For the purposes of maintenance, accrual, and everything else, all we need to know is the value, if she wants to put it in, of her partnership interest. We don't say there's such a partnership. We don't believe there's any value to be attributed, but she's free as a bird in the divorce proceedings to go and put whatever value she wishes to the partnership. And that can be contested or not if it needs be. So I think your Lordship quite correctly pointed out there's no difference between this situation and the situation if it was a third party who should have gone into partnership. There is absolutely no difference. And therefore, that's another basis upon which your Lordship would find there's simply no grounds for the joinder of the trust. My Lord, my learned friend referred your Lordship a few times to B versus B. I don't know if I have a different copy, and I hope I have the same one, but I have it open in front of me, and I can't see any reference in it to a partnership. Perhaps my learned friend can point your Lordship in reply, because I understood her argument to be that B versus B also concern questions of a partnership that were relevant to accrual and maintenance, and it's very similar, and your Lordship can apply it. As I read B versus B, but it's quite a long judgment, my Lord, so I haven't studied each and every paragraph of it. It is the classical situation where a plaintiff sought to join trustees as co-defendants to the defendant, husband, on the basis that there was an abuse of trust form, which is not the case here, or that the defendant was the beneficial owner of the trust assets, which is not the basis of joinder sought here. Also, your Lordship saw the list of SAFLI authorities which were touched on right at the beginning. The other cases are precisely the same, and that's, I'm getting back to my the fundamental flaw in the point. If you look at VW versus VW, U versus U, B versus B, in every single one of those cases, the plaintiff, who was the applicant in the joinder application, was seeking to join the trustees as defendants on the basis that the first defendant, in a family trust context, had abused the trust form, and therefore your Lordship knows all the consequences that can follow with that. Our law is clear. A trust can be joined. We're not here to debate whether a trust can or cannot be joined. We're always saying, my Lord, is that on the basis that the trust is sought to be joined here, there simply is no case made out. As I've pointed out, and perhaps I think it's the matter of VW versus VW, which my learned friend referred to in her supplementary heads, but if your Lordship looks, it's a trite point, but if your Lordship looks, I think at paragraph 11 of the judgment, the learned judge there makes the point. He was just discussing the general principle. There also, it was the joinder of a trust sought on the basis of trust abuse, beneficial ownership, the normal types that one expects a joinder application. And there the learned judge said in paragraph 11, he was debating about whether he had to assess the merits. Your Lordship knows often in these types of application there's a fight about was it or wasn't it an abuse. That's not relevant to whether there must be a joinder or not. That the trial court decides. So in that case, there was a huge opposition put up on the basis that there was never this abuse and so on. And the court said, well, I don't need to assess the merits of the applicant's claim in the divorce action. And the judge said the following: as long as the relief may be claimed against such a party and the latter's interest may be prejudicially affected, joinder becomes necessary. There is no relief sought here that can be claimed against the trust that is relevant to the divorce proceedings. And certainly none set out in either Annexion MAC 4 or MAC 9. My Lord, it is not so simple as my learned friend seeks to suggest to your Lordship, that your Lordship can just order the joinder, as I've already submitted, and the applicant can sort out its amendment later. Your Lordship must be satisfied in this application that there is a legitimate basis made out for the joinder of the trust, and there isn't. And if there isn't, your Lordship, irrespective of the problems with Annexures MAC 4 and MAC 9, and they don't just stop at what your Lordship's identified, because if you look at MAC 9, it seeks the extraordinary relief that when the partnership is dissolved, that the assets of the trust must be taken into account in the personal estates of both the plaintiff and the first defendant, which is something that's an impossibility, because the partnership has got nothing to do with the plaintiff. So on that basis too, there's a significant problem with the manner in which MAC 9 is set up. My Lord, I just want to, if Your Lordship will grant me a second, just page through my notes to see if I haven't missed anything. My Lord, there were various submissions suggesting, but I think I've dealt with this point, that the plaintiff is a partner somehow to this trust under set out under the partnership set out in reply and in MAC 9. There is no, as Your Lordship I think established, we are not a partner. When I say we, I mean the plaintiff is not a partner to the partnership alleged in reply and under MAC 9. Your Lordship asked my learned friend, and I've dealt with this point also, that whether or not the relief against the trust was formulated in the counterclaim, and she submitted that, well, they might have to do an amendment there. And then the answer to Your Lordship was given that, well, we're not asking for the joinder of the trust in the main proceedings, but only in the counterclaim, yes, but they're seeking the joinder of the trustees as a defendant. And they should be seeking it as a defendant in reconvention, not as a defendant in convention. My learned friend, Your Lordship, was questioning her about MAC 9 and that it seeks the dissolution of the partnership between her client, Your Lordship pointed out to her, and the trust. And then my learned friend was trying to explain to Your Lordship why it was still relevant, and she said, well, whenever the defendant gets an asset in her estate, and then she took Your Lordship and referred Your Lordship to the loan account issue, and she said, well, if it's not relevant to his estate, or whether he's an asset in the plaintiff's estate, then the loan account comes. And that is an entirely different issue, my Lord. That is a plain question of whether or not that loan account is an asset in the estate of either party. And Your Lordship, I think it's mentioned in the pleadings as an alternative claim that, well, if the partnership doesn't succeed, then in any way the plaintiff has a loan account, and yes, that's an asset in his estate, but that's got nothing to do with what is sought here. I think Your Lordship dealt with this, my learned friend, but there seemed to be a suggestion at some point of some other tacit agreement of partnership rather than an express oral agreement, when my learned friend referred Your Lordship to certain conduct that had been alleged in the affidavit. Well, Your Lordship called my learned friend to order and pointed out the allegation is quite clearly for an express agreement of partnership concluded between parties. My Lord, there was also a suggestion by my learned friend that the defendant is in partnership with the husband's business. No, my Lord, the allegation is not that the defendant is in partnership with the husband's business. The allegation is that the defendant is in partnership with the trust. It's not the husband's business, it's the trust, and the trust owns the business, and those are the facts. So that's no basis to suggest because the husband or the plaintiff's involved in the business also now that he has a direct interest in the business. What I've pointed out, the notice of objection is not a notice of objection to MAC 9. It could never be. It was simply to the notice of intention to whatever Annex X is. Well, my little friend then made the submission towards the end. She said, well, in pursuing the Rule 30 application, when the applicant had reasons to bring it, the respondent saw the shoe pinched and brought an application to strike. my Lord, with respect, the application to strike is brought in the normal course of proceedings, and this is how they're brought. They're brought after the replying affidavit's been filed for obvious reasons if it relates to the replying affidavit, and they're brought simply on notice and they're argued at the hearing of the application. There's not a requirement for an exchange of papers and the rest, and there's no motivation needed. Either it's a good application or it isn't. And here it clearly is. It's not a question of, and I think the submission was, well, the objection to MAC 9 was bad. Firstly, it's not an objection to MAC 9, and therefore suddenly the application to strike surface. It was brought because there was no basis set out in the replying affidavit for the new case, or no legal sustainable basis to do that. Well, I think that might be it. My Lord, we would ask that your Lordship would dismiss the application, as we've said, primarily with costs. In respect of, that's the main application. In respect of the others, also, either your Lordship will find them academic and not need to go into the merits. We've asked the costs follow the result, and or that your Lordship would dismiss the Rule 30 and grant the application to strike in its full terms, both with costs in favour of the respondent. Thank you, my Lord. Those are my submissions.
Thank you, Mr. Nepomuk. Ms. Veldsman?
My Lord, I'm going to be very brief. In respect of B against B and all the other foratories that I've referred to, Lordship, in the supplementary and amended list of foratories, I did not refer to them as in the sense of a partnership. I referred to them in the general principles of joint of the trust. I could not find any foratory where a partnership was relevant to be joined as a cause of action to be joined to the divorce actions. All the other matters referred to the joint of the trust and the test and the discretion of the court and how the joinder should be effected. If I can then tie on to that part of the argument, my opponent said that the joinder should be not as the second and third defendants in the as proposed in Annexure MAC 9 and read with Annexure X. My Lord, if I read all the cases and where the joint of the trust has been ordered, in all those cases, the trustees are, where joint application was made, the trustees are joined as defendants. There was no, there cannot be another way to join the trustees in a divorce action where joint of application was successful. The reason being the defendant cannot join them as a plaintiff to the action because they are not plaintiffs to the action. They're all defendants, and all the matters that I've referred to your Lordship would notice that in the matter of you versus you, the trust and the trustees are hereby joined as second, third, fourth, fifth, sixth, seventh, and eighth defendants. Same with the matter of VW against VW. There they were joined as the second and third defendants, if I'm not mistaken.
In those matters,
fifth be joined as the second, third, fourth, fifth, and sixth defendants in the divorce action.
In those matters, it was the plaintiff who sought joinder, not so.
Well, my Lord, not in all those matters. I cannot recall which matters the plaintiff sought joinder and in which matters the defendant sought joinder. I know if I can just quickly. The applicant lodged an application. My Lord, I don't know. In the matter of B against B, an amendment was sought to the counterclaim by joining the trust. There was not a joinder application per se, but the amendment was based on joining the defendants. And in that matter, it seems, and it was the wife who was the defendant in the matter, brought the joinder by way of an amendment, an application to amend. And it seems like the defendants, the trustees were joined in their capacity as defendants in B against B. And she was the defendant in the matter. But I must be honest, I've never see a matter where a joinder of a trust has been ordered and the trustees are joined as plaintiffs to the trust. I cannot think how it can be possible, because the defendant is not a plaintiff in the matter. The defendant is a defendant in the matter, and the defendant is
Would they not be joined in reconvention in that instance?
Well, my lord, they are joined in reconvention, but they are joined. I cannot see how they can be joined as plaintiffs in the main action and defendants in reconvention. There are plaintiffs in reconvention and defendants in the main action.
All right.
They must surely. I'm just thinking. Sorry, I'm just thinking out loud, because it must be that that the relief is sought by the defendant against them, but surely they cannot be joined as plaintiffs in the main action. And that was also what did not happen to the matter of B against B. Although it was not a joint application, what they did was they brought an amendment to the counterclaim. And in that amendment, she asked she joined the trustees.
So it was an amendment to the counterclaim.
It was an amendment to the counterclaim, if I can remember correctly. I've quickly glanced through it. As my opponent said, it's quite a lengthy, but it was the wife who brought the amendment in the counterclaim.
Yes.
It was not a joint application, but because the trusts were joined as a consequence of the amendment, the court then considered the joinder also in B against B. The principles of joint of trust. Now, my opponent said that he read in all those matters that the joint of the trust happened as the tried principles, that the trust was a sham, alternatively that the trust was his alter ego. Well, my lord, it's not to say that those are the only reasons that a trust can be joined. It must be a cause of action, and the cause of action is here that there's a partnership. Your lordship does not need to decide whether that cause of action is going to stand the scrutiny of trial. Only what your lordship needs to decide is whether, if there is found to be a partnership between the defendant, who is the applicant in this application, and the trust, whether the trust is going to be affected by it. And the trust is going to be affected by it, by the outcome thereof. And the reason that it doesn't concern this court, the reason why she wants to join the trust as a partner and whether it's going to increase her accrual or not. That is not for this court to decide whether that's a good decision or not. There is a reason why the applicant wants to join the trust. And if it's going to affect her accrual positively and increase her accrual, that's neither here nor there for this court to decide. It's a decision she's going to make, and it's a decision she has the reasons for doing that. In respect of the issue of loan accounts, I did not say to your lordship that the loan account is also a reason why the trust should be joined. I said to your lordship that the joint of the trust and the partnership and the value of the partnership is not the only issue that's going to determine the accrual. I said to your lordship, for example, there's also going to be loan accounts that's going to affect the accrual in both parties' estates. So just to clarify that point.
I see.
Then in respect of the whole issue of the notice of objection, now, your lordship would notice that on page 158 of Annexure X, where it says, it doesn't say notice of intention to amend notice of motion, it said amended notice of motion, but then your lordship would notice that it starts on page 158, it's page 2 of Annexure X.
Sorry, what page was that again?
It's 158, my lord. 158.
Yeah.
According to my pagination. Your lordship would notice it's Annexure X, amended notice of motion. take notice that at the hearing of the application to join the Graham Clark Electrical Trust, duly represented by the plaintiff, that leave be granted to the applicant to amend the notice of motion. The applicant must give notice, at least 10 days notice, in terms of Rule 28, of her intention to amend. But the authority is tried that a notice to an application, well, not an application, the amendment of a notice of motion is similar to that of a pleading. And an application under Rule 28 is an interlocutory application. It doesn't need to have a founding affidavit or an affidavit supporting that. All that needs to be satisfied is that the respondent will have at least 10 days to consider that notice of motion. Alternatively, if it doesn't have 10 days, then the applicant must satisfy the court why condemnation must be given for the non-compliance and give less than 10 days. And that is to make it practical. If one is in a trial and one wishes to amend your pleadings because of the testimony of certain witnesses, then you will serve an amended plea or counterclaim or particulars of claim on the other side, and the parties will consider that. It's not necessary to bring the application with notice and with an affidavit. And it's evident from the context of Annexure X that your lordship is going to be requested at the hearing of this application, which is allowed in terms of Rule 28, to amend the notice of motion. So the applicant did comply with Rule 28, and more than 10 days were afforded to the applicant, to the respondent, to consider the amended notice of motion. It also doesn't need to say in the heading, notice of intention to amend. The amended notice of motion is the correct heading, and that's a normal practice that one adopts when one amends a notice of motion. Not a notice of intention to amend a notice of motion. One merely gives your opponent the amended notice of motion, and you argue that on the date of the hearing of the application. Then in respect of, I'm just going through my list. The respondent says on his version, it's his business. That's the reason why the submission was made. And he started this business in 1999, before the parties got married, before she was a trustee. I think in 1992 he started the business, and then it was converted into a trust. But he says on his version in the answering affidavit, it's his business. And where I refer to him as the trust being his business was in the debate your lordship and I had, when your lordship referred to a third party, and I said to you, but it cannot be, because here is a husband and wife, and the husband is running the trust business, which was his business. So that was the reference in that respect that I've made to the husband's business. It's a trust. We agree it's a trust. The husband is the managing director of the trust business. And the reason why the applicant does not want to proceed with the partnership is because they are involved in very acrimonious divorce litigation, and she doesn't want to continue with the business of the trust where the husband is the managing director of the trust, of the business of the trust, or the managing partner of the trust. And that was throughout her case. She said in the finding and reply that he's the managing partner of the trust, and it's evident from his answering affidavit that he's always been the mind behind the business of the trust. My lord, I think I've addressed all the other issues already in my initial answer to court. Again, I reiterate that the applicant did not replace her cause of action in the reply. She asked for the joinder. That was the application that was brought before your lordship. She asked for a joinder of the trust, and the reason why the trust ought to be joined, there's a partnership. The partnership's assets and liabilities forms part of a third party's assets and liabilities, and that third party is the trust, and the trust is going to be affected by the outcome of the divorce because of the accrual claim and because of the maintenance claim. The one cannot be decided without the other. if I can just refer your lordship to what was said in the matter of VW against VW. Although the right to, it's in paragraph 17, 18, and 19, although the right to share in the accrual only arises at the dissolution of the marriage, both parties are in agreement that the adjudication of the accrual cannot be conveniently separated from the divorce and the applicant's claim for maintenance. I'm in agreement with counsel. There are issues common to both disputes, and there is a reasonable prospect of an overlap of factual issues should be different trials. Separation in this instance would lead to a duplication of evidence and will not materially shorten the proceedings. The possible inconvenience that Trice must suffer in being a party during the adjudication of the divorce and the maintenance claim can be adequately addressed with a suitable cost order should the applicant not succeed in proving the claim against the claim which affects the trust. I'm satisfied that the trust has a direct and substantial interest in the outcome of the divorce action that the applicant has made out of the case for joinder. And that was basically the same conclusion that the different divisions of the courts came to also in B versus B. Where it was said that the paragraph in front of me, and then I closed it, my apologies. It starts, I think I've indicated the correct paragraphs in any event in my heads of argument, or in the supplementary list of authorities, where in paragraph 21, the argument was raised that the launched an attack on the joinder by the plaintiff of the trustees on various fronts. In the main, he continued, the plaintiff's accrual claim against the first defendant is for a sum of money and not transfer of assets. And then he said that that the trust has no direct and substantial interest in the joinder that the amendment as sought by the plaintiff renders. My apology, my lord. It seems that the plaintiff was the person who brought in B versus B, the application to amend her pleadings. That because the relief sought was premised upon abstract, academic, and hypothetical grounds, the application should be dismissed. And then the court said in paragraph 26 in reply, she then deals with Mrs. Gassner's submissions, and then she said that the Honourable Justice Riley says in paragraph 35, I agree with Ms. Gassner that the crucial issue which the trial court will have to determine in assessing the extent of the first defendant's estate for purpose of the plaintiff's accrual is whether the assets ostensibly held in the name of are in fact beneficially owned by the first defendant. That's not the case in our matter, but I need to read this paragraph to your lordship to get to the, in my view, the argument that determination of the plaintiff's accrual claim involves purely an arithmetical calculation is an oversimplification of the issue and can therefore not be correct. She says that since considering the issues, that's the following paragraph, my apologies, paragraph 36 at the end of that paragraph, considering the issues involved, it seems to me that based on dictates of convenience, fairness, good sense, and reasonableness, there ought not to be a multiplicity of actions where the issues are so closely interlinked. It is now commonly accepted that expeditious disposal of litigation is often best served by ventilating all the issues at one hearing. My Lord, I do not have any further submissions and to invite your Lordship to consider both parties' heads of argument. And if there's anything else that I need to address your Lordship on.
No, thank you, Ms. Filtzman. To thank Council for the submissions and the heads of argument submitted. I will reserve the judgment. I intend to advise parties shortly about the date on which the judgment will be delivered. It will be handed out in all likelihood in a sitting similar to this, and then immediately thereafter, the parties will be furnished with an electronic copy by email of the judgment, which I intend to deliver. So the parties will be advised very shortly of the date of delivery of that judgment. So accordingly, the judgment is now reserved, and the court is adjourned.
As a court, please.
As you-
Okay.